The very definition of commercial law is as vast and ever-changing as the world of commerce itself. It's the dynamic interplay of rules, regulations, and customs that dictate how trade operates. But where did it all begin? How did we go from the simple barters of the ancient Silk Road to the intricate web of legislation that governs our digital marketplaces today? Buckle up, because we're about to embark on a journey through time to explore the fascinating evolution of commercial law. Our adventure begins long before the dawn of modern legislation. The ancient world was a hotbed of trade with routes like the famous Silk Road connecting distant empires. Here, merchants from all corners of the known world came together to exchange goods. Despite the absence of a codified legal system, trade flourished. But how? The answer lies in a fascinating combination of factors. Established customs served as the bedrock of trust, while an interconnected network of merchants and trading posts helped to build confidence in far-flung markets. In times of crisis, informal dispute resolution mechanisms stepped in, often utilizing the respected elders or religious leaders of the community to settle disagreements. However, as trade grew more complex, so did the need for more robust legal mechanisms. This period laid the groundwork for the development of true commercial law. Fast forward to medieval Europe, and we find ourselves amidst the bustling markets of a new era. Here, merchants had to contend with the challenges of a more complex economic landscape. Enter the Lex Mercatoria, a system of customary law developed by merchants to fill the gaps left by local legal systems. This groundbreaking concept can be considered a significant milestone in the evolution of commercial law. By establishing a common set of rules for commercial transactions, the Lex Mercatoria ensured greater legal certainty for merchants across borders and regions. These principles, often administered by merchant guilds or courts, addressed issues such as contracts, sales, and liability, providing a much-needed safety net for traders. The historical records and legal texts of this period offer a glimpse into the practical application of the Lex Mercatoria, showcasing its pivotal role in shaping early commercial law. However, the story of commercial law doesn't end here. As we move into the next phase of our journey, we'll explore how the rise of nation-states and the codification of law led to the development of modern commercial codes. So stay tuned and get ready to discover how commercial law took on a life of its own. Welcome back. Now let's dive deeper into the evolution of commercial law. With the rise of nation-states, there was a growing need for centralized legal systems to protect the interests of each country's merchants. National commercial codes and statutes emerged, laying the foundation for modern commercial law. For example, landmark codifications like the Uniform Commercial Code, UCC, in the United States and the French Civil Code played a pivotal role in standardizing and systematizing commercial transactions within national borders. These codes addressed crucial aspects of commercial law, including contracts, sales, negotiable instruments, and secured transactions. But as international trade continued to expand, new challenges arose. Resolving disputes across borders and jurisdictions became more frequent, prompting the need for alternative dispute resolution mechanisms. This led to the emergence of international commercial arbitration as a prominent means of settling commercial disputes outside of national court systems. International commercial arbitration offers several advantages. First and foremost, it provides a neutral forum for resolving disputes, which is particularly important when parties are from different countries with different legal traditions. Additionally, arbitration often allows for more flexibility in choosing arbitrators with specialized expertise in the relevant field of commerce. Furthermore, arbitration proceedings tend to be more confidential than litigation in national courts, which can be beneficial for businesses seeking to protect sensitive information. To understand the practical implications of commercial arbitration, let's consider a hypothetical scenario. Imagine two companies, one based in the United States and the other in China, enter into a contract for the sale of high-tech equipment. The contract stipulates that any disputes arising from the agreement will be settled through international commercial arbitration in accordance with the rules of the International Chamber of Commerce. Now, if a dispute arises between the two parties, they wouldn't turn to the courts in either country for resolution. Instead, they would submit their dispute to an arbitral tribunal constituted in accordance with the ICC rules. The tribunal, comprising one or more neutral arbitrators, would then hear the case and issue a binding decision that both parties are obligated to comply with. As we delve deeper into the digital age, it's essential to explore how commercial law has adapted to the unprecedented challenges and opportunities presented by this new era. The rise of e-commerce and online contracts has brought with it a host of legal complexities. Traditional contract law principles have had to be re-examined and reapplied to the digital realm, raising questions about the formation of online contracts, the use of digital signatures, and the enforceability of online terms and conditions. Legal scholars have extensively analyzed these issues, contributing to the development of guidelines and best practices for drafting and enforcing online contracts. For instance, consider the legal implications of a consumer purchasing a product online. Does the mere clicking of a purchase button constitute a binding contract? How is digital identification verified to ensure the authenticity of parties involved? What are the legal requirements for online dispute resolution? These are just some of the questions that have been at the forefront of legal scholarship in the field of e-commerce. One key area of focus has been the use of electronic signatures. The Uniform Electronic Transactions Act, UETA, in the United States, for instance, was instrumental in providing a legal framework for the validity and enforceability of electronic signatures. Similarly, the European Union's eIDAS regulation has harmonized electronic signature laws across member states, fostering a more predictable legal environment for cross-border e-commerce. Furthermore, legal scholars have grappled with the enforceability of standard form contracts, such as those presented to consumers during online transactions. The principles of contract law have generally held that parties should be bound by the terms they agree to. However, courts have also recognized the power imbalances that may exist in e-commerce transactions, particularly when dealing with standard form contracts drafted by large corporations. This has led to discussions about the extent to which courts should intervene to ensure fairness and transparency in online contract terms. In addition to addressing contractual issues, legal scholarship has also played a vital role in shaping data protection laws in the context of e-commerce. The collection and processing of personal data during online transactions raise significant privacy concerns. Landmark regulations such as the General Data Protection Regulation, GDPR, in the European Union and the California Consumer Privacy Act, CCPA, in the United States have set new standards for businesses in terms of data collection, storage, and usage. Legal scholars have been instrumental in shaping these regulations, ensuring that they strike a balance between protecting consumer privacy and allowing for innovation in the digital marketplace. As we continue our journey through the digital revolution's impact on commercial law, we must now turn our attention to another critical aspect: intellectual property rights in the age of technology. The ease of copying and distributing digital content has brought new challenges to the protection of intellectual property. Legal scholarship has been at the forefront of addressing these challenges, analyzing the effectiveness of existing legal frameworks in safeguarding intellectual property in the digital realm. One area of particular concern is the protection of software and databases. Legal scholars have examined the application of copyright law to software code, exploring issues such as ownership rights, licensing, and the protection of source code and object code. Additionally, the legal status of open-source software and the use of artificial intelligence in software development have raised new questions about intellectual property rights that legal scholars are actively researching. Another important area of focus has been the protection of trademarks and trade secrets in the digital marketplace. As businesses increasingly rely on online platforms for marketing and sales, legal scholars have analyzed the challenges of enforcing trademark rights in cyberspace. The use of domain names, social media, and online marketplaces has raised questions about the scope and enforceability of trademark protection in the digital age. Moreover, the enforceability of non-disclosure agreements and trade secret laws in the context of online transactions has been a subject of ongoing legal scholarship, particularly in light of the ease with which confidential information can be shared and misused in cyberspace. As we conclude our exploration of the digital revolution's impact on commercial law, it's essential to address one of the most disruptive innovations, cryptocurrencies and blockchain technology. The rise of cryptocurrencies such as Bitcoin and Ethereum has challenged traditional notions of currency and financial transactions. Legal scholars have been grappling with the regulatory status of cryptocurrencies, exploring their implications for tax purposes, money laundering, and consumer protection. The decentralized nature of blockchain technology and the use of smart contracts have also raised novel legal questions about jurisdiction, contract enforcement, and the legal recognition of digital assets. Navigating the world of commercial law in the digital age requires a deep understanding of the key concepts and principles we've discussed throughout this journey. Whether you're a business owner, a legal professional, or simply someone looking to understand the complexities of modern commerce, having a grasp of commercial law is essential. Now let's turn our attention to the practical implications of commercial law in today's world. When drafting contracts for digital transactions, it's crucial to include specific clauses that address issues such as digital signatures, data protection, and dispute resolution mechanisms. Ensuring compliance with relevant data protection laws and intellectual property regulations is also paramount in the digital environment. Furthermore, having effective dispute resolution mechanisms in place can help mitigate potential conflicts arising from e-commerce transactions. Finally, staying informed about technological advancements and their impact on commercial law is essential for businesses and legal practitioners alike. As technology continues to evolve, commercial law must adapt to keep pace with the changing needs of the digital marketplace. The journey through the evolution of commercial law has been nothing short of remarkable. From the rudimentary trade practices of the Silk Road to the sophisticated legal frameworks of today, we've witnessed an incredible transformation driven by the relentless march of technology and changing societal norms. The digital revolution has been a game changer, forcing us to reimagine how we conduct business and interact in the global marketplace. And as we look to the future, it's clear that commercial law must continue to evolve to meet the challenges posed by emerging technologies and global commerce. But this is not just a tale of legal complexity. At its core, the story of commercial law is a reflection of human ingenuity and our ability to adapt, innovate, and create systems that facilitate trade and economic growth. It's a testament to our collective efforts to establish order and predictability in an ever-changing world. And our journey through this fascinating world is far from over. As long as commerce continues to thrive, so too will the field of commercial law. And who knows what new chapters await us in this epic legal saga. If you found this journey through the evolution of commercial law insightful, don't forget to stay tuned for more captivating content. Thank you for joining me on this adventure, and until next time, happy learning.